What happened in the congressional hearing room yesterday left Supreme Court Justice Neil Gorsuch visibly challenged and the nation's cultural and legal communities buzzing as American actor Jonathan Roumie delivered a public appeal so poignant and insightful that it reshaped a high-profile Judiciary Committee hearing in just under 3 minutes. A routine oversight session transformed into one of the most remarkable public confrontations in recent memory when Gorsuch attempted to dismiss Roumie's concerns about First Amendment jurisprudence. With all due respect, Mr. Roumie, these are complex constitutional matters that require significant legal expertise, Gorsuch said with unmistakable condescension after Roumie had questioned the consistency of the court's recent opinions. The committee room fell silent, everyone present sensing a pivotal moment. What followed was a masterclass in principled public advocacy that not even the most seasoned justice was prepared to fully counter. Hit that like button and subscribe because Jonathan Roumie's response didn't just leave Gorsuch pondering. It highlighted contradictions in the Supreme Court's recent jurisprudence from a public trust perspective that scholars and citizens alike will be discussing for years to come. To understand why this confrontation has sent shockwaves through America's legal establishment and beyond, you need to know who these two figures are and why this clash represents far more than a momentary exchange. If you're finding this analysis valuable, take a second to hit that like button and subscribe to our channel. We bring you these in-depth breakdowns of crucial moments in American governance that mainstream media often glosses over. Your support helps us continue this important work. Supreme Court Justice Neil Gorsuch, 56, has served on the nation's highest court since his confirmation in 2017. With his Columbia and Harvard law education and background on the 10th Circuit Court of Appeals, Gorsuch is widely regarded as a staunch textualist and originalist. His opinions have largely aligned with the court's conservative majority, particularly on issues involving religious liberty, free speech, and administrative law. Since joining the Supreme Court, Gorsuch has cultivated an image of intellectual rigor and principled judicial philosophy. In public appearances, he frequently emphasizes the importance of constitutional principles and the need for the court to remain above partisan politics. The congressional oversight hearing, where this confrontation occurred, focused on the court's recent First Amendment decisions, particularly cases involving protest rights, campaign finance, and religious expression. These decisions have generated significant controversy, with critics arguing they represent inconsistent application of constitutional principles depending on the ideological valence of the case. American actor Jonathan Roumie, widely known for his portrayal of Jesus in the acclaimed series The Chosen, brings a completely different background and perspective. Before gaining global recognition for his acting career, Roumie studied film at the University of Southern California. While not a lawyer or politician, Roumie has established himself as a prominent cultural voice, often speaking on matters of faith, justice, and the role of art in public discourse. His deep connection with audiences, particularly those interested in moral and spiritual themes, gives him a unique platform. What wasn't widely known before the hearing was Roumie's personal dedication to understanding how legal principles, especially those concerning freedom of expression and belief, are perceived by everyday Americans. Through informal discussions with constitutional scholars and a genuine curiosity about judicial consistency, Roumie had identified what he felt were troubling patterns in how the court applied supposedly neutral principles differently depending on the subject matter and parties involved, leading him to accept an invitation to testify as a public figure concerned with judicial transparency and public trust. The stage for this unique confrontation was set when the Judiciary Committee scheduled an oversight hearing on Supreme Court decision-making and constitutional interpretation. Such hearings are rare as justices typically avoid testifying before Congress except during confirmation. However, amid growing concerns about court legitimacy and calls for ethics reform, Gorsuch and 2 other justices agreed to appear. Chairman Jim Jordan announced that, in addition to committee members, invited public figures would have 5 minutes for remarks. Few expected that Roumie's turn at the microphone would produce one of the most remarkable exchanges in the history of court-Congress relations, or that his powerful public appeal would leave a Supreme Court justice visibly struggling to defend his own jurisprudence against the perception of inconsistency. The House Judiciary Committee hearing room was filled to capacity with additional spectators watching on screens in an overflow room. The atmosphere was tense but formal, as Justice Gorsuch finished responding to routine questions from several senior committee members about the court's procedures and decision-making process. When the chairman announced, "The invited public figure, Mr. Jonathan Roumie, is recognized for 5 minutes," Gorsuch shifted slightly in his chair, perhaps expecting another round of general inquiries about public perception or cultural impact. Roumie, dressed in a classic dark suit, organized his thoughts methodically before beginning. "Thank you, Mr. Chairman. Justice Gorsuch, I appreciate your appearance today," Roumie began, his tone professional and earnest. "I'd like to focus specifically on the public's perception of the court's application of First Amendment principles across different contexts. Justice Gorsuch, your own writings and speeches often emphasize that consistency in constitutional interpretation is essential to the rule of law. Would you say that remains your position?" Gorsuch nodded, seemingly comfortable with the opening question. "Yes, Mr. Roumie, consistent application of constitutional principles is fundamental to the court's legitimacy and the rule of law." "I couldn't agree more," Roumie replied. "With that principle in mind, I'd like to explore how the court's application of First Amendment standards appears in different contexts over the past 3 terms, from the perspective of an engaged citizen." Roumie then referenced a public report, Perceptions of Justice, created by a nonpartisan watchdog group, which highlighted several cases. Justice Gorsuch, in cases like Americans for Prosperity versus Bonta, which involved disclosure requirements for charitable donors, the court has found that even indirect burdens on association rights trigger strict scrutiny. Yet in cases such as McKesson versus Doe, involving protest organizers, the court permitted potential liability for others' actions under a much lower standard. From a citizen's perspective, this appears to be a different treatment for what fundamentally seems like the same First Amendment right. Could you explain the constitutional principle that, to an outside observer, justifies this difference? Gorsuch shifted in his seat, clearly not expecting such a direct and well-researched, albeit lay comparison. "Those cases involve different First Amendment contexts, Mr. Roumie. Donor privacy implicates association rights in a distinct way from protest activity." "But Justice Gorsuch," Roumie pressed, "both cases, to the common person, seem to fundamentally involve the same First Amendment right, freedom of association. In Bonta, the burden was disclosure of information to state regulators with confidentiality requirements. In McKesson, the burden was potential financial ruin for organizing a protest where someone else broke the law. Why would the former appear to trigger strict scrutiny while the latter seems to receive minimal protection?" The room grew quieter as attendees realized they were witnessing not just routine questioning, but a powerful public challenge to the court's perceived impartiality. Gorsuch's expression shifted from mild surprise to visible concentration. "The specific context and government interests differ significantly," he offered. "The court's jurisprudence recognizes that First Amendment principles apply differently across varying factual scenarios. Different applications, certainly," Roumie acknowledged. "But shouldn't the underlying principles, the ones that build public trust, remain consistent?" Let me point to another example, also highlighted in the Perceptions of Justice report. He looked at his notes. In Kennedy versus Bremerton School District, the court found that a public school coach had the right to engage in visible prayer at school events, emphasizing that even potential indirect coercion of students was too speculative to limit this expression. Yet in City of Austin versus Reagan National Advertising, decided just months earlier, the court permitted significant restrictions on sign content because of speculative, aesthetic, and safety concerns. Both cases, from an outsider's view, involve balancing expressive rights against speculative harms. Yet the court appears to have applied entirely different analytical frameworks. What constitutional principle explains this apparent discrepancy, and how can the public understand it as consistent? Gorsuch's discomfort was now evident to everyone in the room. "Mr. Roumie, these are complex constitutional questions that require detailed analysis of precedent and context. I don't think they can be reduced to simple comparisons." Roumie maintained his earnest, professional demeanor. "I'm not suggesting simplistic comparisons, Justice Gorsuch. I'm asking about the consistent application of constitutional principles, something you yourself have often emphasized is essential to the rule of law and public confidence." The Perceptions of Justice report also noted this. In cases like Americans for Prosperity, the court has written that history and tradition must guide First Amendment analysis. Yet in Kennedy, the majority largely dismissed historical practices regarding church-state separation in public schools, emphasizing instead modern conceptions of religious expression. How can the public reconcile these different approaches to history and tradition in First Amendment cases decided in the same term? The committee room was now completely silent. Several legal reporters were frantically taking notes, recognizing that Roumie was highlighting perceived inconsistencies that public advocacy groups and some scholars had identified, but that rarely get addressed so directly and publicly in congressional hearings. Gorsuch, appearing increasingly uncomfortable, responded, "With all due respect, Mr. Roumie, these are complex constitutional matters that require significant legal expertise. Each case presents unique considerations that the court must evaluate based on text, history, and precedent." The condescension in his tone was unmistakable, and it proved to be a critical error. Several committee members glanced at each other, recognizing the dismissive implication that Roumie, as an actor, lacked the gravitas or legal expertise to engage with these issues. Roumie paused, his expression unchanged. "Justice Gorsuch," Roumie stated calmly, "I may not be a lawyer, but I spend my life studying human behavior, motivations, and the stories that shape our understanding of justice and fairness. I'm quite familiar with how fundamental principles should work in practice, and how their inconsistent application impacts trust." Without raising his voice or changing his earnest demeanor, he continued, "The question isn't whether cases have different facts. Of course they do. The question is whether the court applies consistent analytical frameworks in a way that is perceived as impartial, regardless of the identity of the speakers or the ideological valence of the speech. From the public's perspective, the evidence suggests it does not." Roumie then proceeded to demonstrate his point with striking clarity, displaying excerpts from a compiled public analysis titled "An Examination of First Amendment Scrutiny," also a product of the nonpartisan watchdog group, on the display screen. In these examples, both from opinions within the past two terms, the court appeared to apply strict scrutiny to protect religious speech while applying rational basis review to nearly identical secular speech. To the average citizen, the constitutional text makes no such distinction. Our founding fathers, whose intentions you've emphasized as controlling, envisioned a First Amendment that offered no hierarchy of protected speech. Religious and secular, conservative and progressive speech were, in principle, entitled to the same protection. Yet the court's recent decisions have, from an external perspective, effectively created preferred categories of expression. The clear articulation of his concerns, grounded in widely understood principles of fairness, was now evident to everyone in the room. This wasn't political grandstanding, but a compelling public critique, highlighting how the court's own interpretive tools, when inconsistently applied, could undermine public trust. Gorsuch attempted to regain control of the exchange. "Mr. Roumie, the court strives for consistency, but each case presents unique." "Justice Gorsuch," Roumie interjected politely but firmly, "the Perceptions of Justice report identified 7 major First Amendment cases from the past 3 terms where the court appeared to apply completely different levels of scrutiny to government actions that impose similar burdens on speech. The only consistent pattern, to many observers, is the apparent ideological direction of the outcome, not the stated constitutional analysis." He then showed a graphic representation of these cases, derived from the report, with their holdings and level of scrutiny applied. When conservative religious speech is at issue, the court appears to consistently apply strict scrutiny. When progressive political speech or workers' rights are at issue, rational basis or intermediate scrutiny suddenly seems appropriate. This, Justice Gorsuch, does not look like consistent constitutionalism to the public. It looks like outcome-driven jurisprudence. The clarity and moral weight of his presentation was undeniable. Even Republican committee members were watching intently, several nodding despite their political differences with Roumie. This kind of direct appeal to fairness and consistency transcended partisan lines. Furthermore, Roumie continued, "Your own public statements, Justice Gorsuch, have often emphasized that neutral principles of constitutional interpretation must remain neutral regardless of the subject matter. Yet the court's recent First Amendment jurisprudence, from a public perspective, shows precisely the subject matter discrimination that concerned many." As his questioning continued, Roumie methodically highlighted specific perceived inconsistencies in the court's recent decisions, always returning to Gorsuch's own stated principles of interpretation and the public's expectation of fairness. His ability to frame complex issues in terms of universally understood principles of consistency and justice was evident in every carefully framed question. The dynamics in the hearing room had completely shifted. What began as routine oversight had transformed into a powerful public discourse on judicial legitimacy, led by someone clearly adept at conveying profound ideas with moral weight. Gorsuch, initially confident and slightly dismissive, now appeared genuinely challenged by the substance and clarity of Roumie's critique. The confrontation reached its climax when Roumie looked directly at Gorsuch. "Justice Gorsuch, I'd like to discuss something specific that illuminates this issue, something from your own public statements. Before your confirmation and in many speeches since, you have often spoken about the importance of viewpoint neutrality in First Amendment analysis. You've stated that the cardinal sin of First Amendment jurisprudence is treating similar speech differently based on the identity of the speaker or the popularity of the message." Gorsuch's expression changed to one of surprise. Few public figures, let alone invited speakers at a congressional hearing, would reference such precise legal tenets. "I'm familiar with my statements, Mr. Roumie," he said cautiously. "I'm glad to hear that," Roumie replied, "because through publicly available data and analyses compiled by various legal observers, a pattern emerges from the First Amendment cases since you joined the court. In cases involving religious speakers, corporate interests, or conservative advocacy groups, the court, with your participation, appears to have applied strict scrutiny a very high percentage of the time. Yet in cases involving protesters, labor organizations, or civil rights groups with seemingly identical constitutional claims, it appears intermediate or rational basis scrutiny was applied with similar frequency. This, from a public vantage point, suggests an inconsistency." The room was completely silent as Roumie continued. "This pattern, to the public, directly contradicts the principle you've often articulated. It suggests that the determining factor in the court's First Amendment analysis is not consistently the constitutional text, history, or precedent, but rather the identity of the speaker and the ideological content of their message." He then displayed via a chart from the Perceptions of Justice report how two opinions, written just months apart, appeared to apply completely different analytical frameworks to nearly identical government restrictions on speech. "The only meaningful difference identified," Roumie stated, "was the identity of the speakers and the content of their message." Gorsuch, visibly flustered, adjusted his tie. "Mr. Roumie, judicial opinions address the specific cases before the court. Different contexts require different analyses." "Different contexts, certainly," Roumie acknowledged that, "but different constitutional principles? Your own public statements emphasize that while applications may vary, the underlying constitutional principles must remain consistent regardless of who is speaking or what they're saying." He paused, then delivered the defining moment of the hearing. "Justice Gorsuch, the First Amendment, as understood by the American people, doesn't protect only popular speech or powerful speakers. It doesn't have a carve-out for certain ideological viewpoints. The same fundamental constitutional principles must appear to apply whether the speaker is a corporation or a protester, a religious organization, or a labor union. When the court appears to apply strict scrutiny to protect speech it favors, while applying minimal scrutiny to speech it doesn't, it undermines the very neutrality that legitimizes judicial review in the eyes of the public." Gorsuch, clearly unprepared for this level of public and morally charged critique, attempted to pivot. "The court strives to apply constitutional principles even-handedly, Mr. Roumie. Reasonable minds can differ on specific applications." "Reasonable minds can certainly differ," Roumie replied, "but principles shouldn't appear to differ depending on who's speaking. That's the essence of viewpoint neutrality, a concept you've championed in your own statements, but one that, from the public's perspective, the court's record has not consistently reflected." Several phones in the gallery were now raised, capturing what was clearly becoming a historic exchange. Legal reporters from major publications were typing frantically, recognizing that this wasn't merely political theater, but a substantive public challenge to the court's perceived legitimacy, with significant implications for First Amendment jurisprudence and public trust. Gorsuch shifted in his seat, his legendary composure visibly cracking. "Mr. Roumie, you're conflating different lines of First Amendment precedent to create an appearance of inconsistency." "I'm not conflating anything, Justice Gorsuch," Roumie replied calmly. "I'm simply presenting how these cases are perceived by concerned citizens, drawing from analyses that highlight specific instances. For example, in Americans for Prosperity, the court stated that even minor burdens on association must survive strict scrutiny. Yet in Cedar Point Nursery, decided that same term, a significant burden on labor organizing, which is also a form of association protected by the First Amendment, appeared to receive rational basis review. And let's discuss your repeated references to history and tradition in First Amendment cases. In Kennedy, the court appeared to virtually ignore the long historical tradition of limiting school officials' religious expression. Yet in Bonte, historical practice was emphasized as determinative. To an outsider, the principle seems to apply differently depending on the case. The committee chair glanced at the clock and signaled that Roumie's time was almost expired. Roumie nodded acknowledgement and delivered his final points with profound sincerity. Justice Gorsuch, I respect the court as an institution and your role within it. What I question, and what many Americans question, is the perception of inconsistent application of constitutional principles based on who is speaking and what they are saying. When the court appears to apply strict scrutiny to protect speech, it favors while applying minimal scrutiny to speech it doesn't. It undermines the First Amendment's core purpose, protecting all expression regardless of its popularity or the power of the speaker. He looked directly at Gorsuch. The greatest threat to First Amendment freedoms isn't any particular restriction on speech. It's the perception that constitutional protection depends on who you are and what you're saying rather than the nature of the government action. If the court wishes to maintain its legitimacy as the guardian of constitutional rights, it must be seen to apply its interpretive methods consistently, regardless of the identity of the speaker or the ideological valence of the speech. The hearing room erupted with murmurs. Several committee members, including Republicans known for their respect for thoughtful discourse, were nodding. Journalists were frantically taking notes. Gorsuch sat visibly challenged, clearly unprepared for such a direct and morally resonant public critique of the court's perceived consistency. A senior Republican committee member leaned over to his Democratic colleague and whispered, I might not always agree with his public statements, but that was a masterclass in conveying a principled concern. He just highlighted real inconsistencies from the public's perspective. Chairman Jordan, recognizing the historical significance of the moment, said, the invited speaker's time has expired, but the witness may respond to his points. Gorsuch, gathering himself, said, the court strives to apply constitutional principles consistently across all cases. What may appear as inconsistencies often reflect the complex interplay of different lines of precedent and the unique facts of each case. I appreciate Mr. Roumie's perspective and his obvious preparation for today's hearing. His response, while professional, noticeably failed to address any of the specific apparent contradictions Roumie had identified. The Supreme Court justice, known for his detailed and articulate opinions, had been rendered essentially speechless by the earnest public questioning from an actor he had initially attempted to dismiss as lacking legal expertise. As the hearing moved to the next questioner, cameras caught several senior committee members approaching Roumie with evident respect. A veteran Republican congressman was overheard saying, that was one of the most compelling public appeals for judicial consistency I've seen in this committee in 20 years. The aftermath of the Roumie-Gorsuch exchange was immediate and far-reaching. Within hours, video clips of the confrontation had gone viral across social media platforms. #PublicTrust and #Roumie challenges. Gorsuch became trending topics nationwide, with the exchange generating over 30 million views in just 24 hours. Legal scholars from across the political spectrum weighed in on the implications of the exchange. Harvard Law professor Lawrence Tribe tweeted, in 50 years of constitutional law, I've rarely seen such a potent and public challenge to the court's First Amendment jurisprudence. Mr. Roumie identified genuinely concerning inconsistencies that deserve serious engagement from the court, not just from lawyers, but from all citizens. Even conservative legal figures acknowledge the significance of his appeal. Former federal judge J. Michael Luttig wrote, while I often support the court's recent First Amendment decisions, Mr. Roumie's articulation of inconsistent scrutiny standards raises legitimate public concerns about the principled application of constitutional doctrine. His presentation was remarkably persuasive as a public advocate and deserves serious consideration. Major news outlets quickly moved beyond reporting on the personal dynamics of the exchange to analyzing the substantive public issues Roumie had raised. The New York Times published an in-depth examination titled, A Crisis of Confidence, the court's divergent approaches to First Amendment claims, which extensively quoted Roumie's framing of the issue and noted that many constitutional scholars found his identification of inconsistent standards, seen through a public lens, persuasive. CNN assembled a panel of First Amendment experts who largely confirmed the perceptions Roumie had articulated. What made this exchange so remarkable, said one prominent conservative legal scholar, was that he wasn't making partisan political points. He was identifying genuine public concerns about jurisprudential inconsistencies that many of us have observed, but that rarely get addressed so directly and publicly in congressional hearings by someone with such a platform. Within days, media studies and public policy departments across the country requested permission to use video of the confrontation in courses on public advocacy and judicial ethics. Georgetown Law Center announced a symposium titled Public Trust and Judicial Consistency in First Amendment Jurisprudence, inspired directly by the issues raised during the hearing. The Yale Law Journal commissioned a special issue examining the scrutiny disparities that Roumie had highlighted from a public trust perspective for Justice Gorsuch. For Justice Gorsuch, the hearing represented a significant public challenge. Court watchers noted that his dismissive response to Roumie's initial concerns, followed by his inability to substantively address the public's perception of inconsistency, momentarily strained his reputation as a principled jurist. The Washington Post published an analysis titled Gorsuch's First Amendment Jurisprudence, a Test of Public Trust, examining whether the court's voting pattern indeed showed the inconsistencies Roumie had illuminated. Legal blogs and forums were filled with discussions of what many were now calling the Roumie metric, a challenge for justices to demonstrate consistent constitutional scrutiny, understandable to the public, regardless of the identity of the speaker or the ideological valence of the speech. Law professors reported that students were beginning to apply this framework of public accountability to evaluate Supreme Court decisions across various constitutional provisions. Within the Supreme Court itself, sources suggested that the exchange had prompted internal discussions about doctrinal consistency and public legitimacy. According to court insiders who spoke anonymously to the New Yorker, several justices had privately acknowledged that Roumie's articulation had identified real tensions in the court's recent First Amendment jurisprudence regarding public perception. Even some conservative justices were reportedly concerned about the perception that constitutional protection varied based on the identity of the speaker. There's a sense among some justices that this exchange exposed vulnerabilities in the court's approach to First Amendment cases from a public relations standpoint, one source told The New Yorker. When a prominent public figure can identify such clear patterns of inconsistent scrutiny from a lay perspective, it raises questions about whether the court is truly applying neutral principles of constitutional interpretation in a way that resonates with the American people. For Jonathan Roumie, the hearing transformed his national profile beyond entertainment. Universities and public policy institutes across the country invited him to speak about public trust, judicial transparency, and the role of cultural figures in civic dialogue. The American Civil Liberties Union asked him to deliver a keynote address at their annual convention on consistent application of rights and public perception. Major civil liberties organizations highlighted his performance as evidence of the importance of engaged citizens and moral voices in constitutional dialogue. The National Association for Civic Engagement established a Jonathan Roumie Award for principled public advocacy for individuals who demonstrate exceptional ability to articulate public concerns about inconsistencies in institutional practices. What Jonathan Roumie demonstrated wasn't just individual brilliance, said the dean of a prominent public policy school in a widely shared editorial, but the value of perspectives from engaged citizens who grapple with the impact of legal decisions on everyday Americans. His ability to connect with a broad public and articulate concerns about consistency brought unique insights into the real-world consequences of doctrinal inconsistency that purely academic or political perspectives often miss. Perhaps most significantly, the exchange changed how Congress perceived its oversight role regarding the Supreme Court. Acknowledging the importance of public input, public policy commentators began discussing what some called the Roumie framework of public advocacy, focusing on deeply held principles and public trust rather than political talking points or personal attacks. A Pew Research poll conducted 2 weeks after the hearing showed that 71% of Americans believe Supreme Court justices should be required to explain apparent inconsistencies in their application of constitutional principles in a way that is understandable and reassuring to the public. Most notably, these views cross partisan lines, with majorities of both Republicans and Democrats supporting greater public accountability from the court. 3 months after the hearing, the impact continued to reverberate when the Supreme Court heard oral arguments in a major First Amendment case involving protest rights. Court observers noted that several justices, including Gorsuch, asked questions specifically addressing the public perception of consistency of scrutiny standards across different types of speakers, questions that directly echoed Roumie's public appeal. When the decision was announced 4 months later, legal scholars were surprised to see Gorsuch's concurring opinion, which took pains to address the consistency of First Amendment doctrine across different contexts. While not citing Roumie directly, his opinion acknowledged that the court must be vigilant in applying consistent standards of scrutiny in a way that reinforces public trust, regardless of the identity of the speaker or the popularity of the message. Recognizing this as a core principle of First Amendment jurisprudence that must guide all of our decisions in this area. Justice Gorsuch's apparent evolution on First Amendment consistency is remarkable, wrote a constitutional law professor in SCOTUS blog. His current emphasis on viewpoint neutrality and consistently applying scrutiny represents a notable shift from previous opinions in how he publicly articulates the court's reasoning. While justices rarely acknowledge the influences on their thinking, this evolution suggests that principled public critique from engaged citizens can indeed impact judicial articulation and, implicitly, jurisprudence. 6 months after the hearing, advocacy groups, inspired by Roumie's testimony, rallied behind a judicial transparency and public trust initiative, urging Congress to require the Supreme Court to explicitly identify and publicly justify the level of scrutiny applied in constitutional cases in a clear, accessible manner. The initiative gained surprising bipartisan support. Several conservative legal organizations endorsed the effort as promoting principled constitutionalism and reinforcing public faith in judicial restraint for everyday Americans, particularly those who feel unheard by legal institutions. The Roumie-Gorsuch exchange became a powerful symbol of how sincerity and principled public advocacy can overcome assumptions and stereotypes. Social media filled with comments from young people from diverse backgrounds expressing inspiration at seeing someone like Roumie hold one of the nation's most powerful legal figures accountable through a compelling appeal to fairness. Watching Jonathan Roumie articulate complex inconsistencies showed me what's possible when you connect deeply with principles of justice and human experience, wrote a first-year public policy student in a viral TikTok video. He didn't raise his voice or get emotional. He just systematically highlighted the contradictions in their reasoning from a perspective that everyone could understand. 1 year after the hearing, the Georgetown Public Policy Review published a comprehensive study, The Public Perception of Scrutiny Standards, examining the Supreme Court's application of scrutiny standards across different categories of First Amendment cases. The study, which confirmed many of the patterns Roumie had highlighted from a public trust perspective, has since become required reading in public policy and constitutional law courses across the country. As for Justice Gorsuch, while he never directly acknowledged the impact of the exchange, court watchers noted a distinct evolution in his public articulation and approach to First Amendment cases. His subsequent opinions showed greater attention to the consistent application of scrutiny standards in a way that was more transparent to the public, with one law professor observing, Gorsuch's current First Amendment jurisprudence shows a heightened awareness of the need for principled consistency across different categories of speakers in a clear effort to address public concerns, a significant shift from his earlier articulations. The confrontation between Roumie and Gorsuch ultimately transcended a momentary exchange to become a case study in public accountability and the importance of consistent principle in judicial interpretation. Public policy schools and law schools now teach it as an example of effective public advocacy and the value of substantive dialogue between the public and institutions of governance. Perhaps the most lasting legacy came in the form of a new public policy casebook, which featured a chapter on judicial consistency and public trust that began with an account of the exchange. The chapter concluded, "This incident reminds us that constitutional interpretation is strengthened, not weakened, when it faces rigorous scrutiny from an engaged citizenry. When justices are challenged to explain apparent inconsistencies in their application of constitutional principles in a way that resonates with the public, the resulting dialogue enhances the legitimacy of the court and the coherence of constitutional doctrine, both to legal professionals and to everyday Americans. If this story of principled public advocacy and a demand for consistent application of justice inspired you, hit that like button and subscribe for more content that shows how earnest engagement and a commitment to core principles can speak truth to power. Share your thoughts in the comments about other moments when public voices have advanced our constitutional dialogue. Because when we understand our rights and demand consistent, transparent protection of them, we all become stronger citizens of our constitutional republic.